Thanks for joining us on the Property Rights Australia videocast series. Today I'm speaking to Tom Marland. How are you, mate?
Good, mate. Thanks for taking your time out to talk with me.
And so you work in the legal space. You have done for quite some time. So from keeping that as a sort of high level context here, can you briefly describe how you got involved with PRA and property rights way back when?
Yeah, well, went to the first general meeting in Roma in 2000. So I was first year university, and my mother and father our family properties were heavily impacted by the vegetation management laws, and my mum was from the Cattlemen's Union background and was very good friends with people like Ashley Mackay and John Purcell and Dominic Devine. So I was pretty much from the start of the organisation was there. I was actually voted on the draft constitution, and obviously it feels like a long time ago. But it's been I've had a proud association. My family's had a proud association with the organisation, and it's good to see that it's still doing good work for landowners today. So I think I was on the board 2005. So obviously, Vegetation Management Act was, since it was first sort of proposed in 1998, was a huge impact to the industry. It had a huge individual impact to landowners. We literally saw billions of dollars worth of productivity wiped out of rural and regional Australia at the time. And so when I was on the board, I went up to Paradise Lagoons in 2005 with my mum and dad, and was nominated for secretary. I was still at university at the time, obviously, and put my hand up and thought, well, I can do as good a job as anyone else. And John Purcell was president at that time, and that was when we'd been approached by Professor Surya Ratnapala, who was a constitutional expert from University of Queensland, who actually lectured me at uni, and we looked at canvassing some high court or some legal challenges to the vegetation management regime at the time. So it was a very exciting time. It's a very complex area of law, so it wasn't an easy as done as it is said. So I actually was working with Surrey at the time at University of Queensland, and working with the board and working with some high-level law firms and barristers to try and see some pathways forward. There were some pathways forward, but they all take, they weren't a quick fix. Looking at timeframes of 5 to 10 years, looking at federal court actions, high court actions, and costing millions of dollars. So it was decided at the time. We got some advice from some pretty senior barristers that while there was avenues there, that there might have been better money, better spent in other areas. So the board decided not to pursue those areas. So it was an interesting time. It was a challenging time, but I still think the work that we did in that space, certainly elevated the issue from a political level, and we were able to get some outcomes that, while ultimately couldn't solve the problem, I think helped to alleviate some of the issues that we were dealing with at the time.
But let me ask you before we go on to the next question as a point of clarity, because I've heard this said a few times that the area of law that you're talking about is complicated. Is it complicated because of the legislation that's been enacted over time, or is it complicated because of the nature of land rights under Commonwealth and Queensland legislation?
Probably a bit of both. I think land rights, or when I talk about property rights, it's a complicated, actually a very complicated area of law, and I guess the rights that we have attracted to the property we own. If we understood that, especially in Queensland, where those rights can be quickly lost if no one's there to defend them. So, under our Queensland Constitution, we don't have an upper house. So if the government want to come and take your land for nothing, they can. That has been a really stark lesson for me. Doesn't matter if you own freehold, leasehold, nothing. Government can change the act tomorrow and resume your land or impact your land, and your rights are zero. So we fight legal battles, but we also fight political battles, but we also try and fight community-led battles, which we've often seen in different spaces, from introduction of the Act to start with, through coal seam gas, through all sorts of different things. So, the rights we have today are easily lost unless someone stands up and fights for them. But also the complexity of legislation that goes forward. I mean, I spend my life reading legislation and going through it, and I'd be lying to you if I fully understood it. I think any person who fully understood the land regulation regimes in Queensland would overlap with federal legislation would be lying to you, because it changes all the time. I mean, I'd probably spend more time unfortunately, in the last 10 years in courtrooms defending landowners for tree clearing trials, tree clearing matters, whether it be a fire break or a thinning permit, or going outside of the areas they could legally clear, and the complexity of that legislation, and the ever-changing policy nature of that legislation as well, just at a state level, is quite difficult. And then you add in the federal levels on top of that. It's just so some landowner going out there and trying to manage their properties on a given day, I think would be really challenged to know whether they're actually complying with the law or if they aren't. And that's a really sad reality. I mean, you basically, you got to be sitting on a dozer with stacks full of legislation, and have a really finite understanding of how that'll all put together to be able to act, to do anything, and to not even to develop your property, just to maintain and manage it. And that might be just putting in a fire break. That might be spraying a weed. That might be, reducing woody regrowth, whatever it is. The laws are so complex. It's designed actually not to do anything. You're basically better off just staying in the homestead and letting the suckers up grow up around you. Yeah, look, I don't say before. I don't want to sound pessimistic about it in the future, but I deal with it every day. So, I look at it from a practical and realistic point of view, and the regimes are getting worse before they get better. They're not seeing any practicalities. We're seeing more bushfires. We're seeing more adverse environmental outcomes occurring because the people who are writing the legislation have got no concept or connection with land. They just write it for political reasons. So we're not, I fight legal battles, but most of them are political. I think we are starting to see an increasing ramp up on the use of environmental regulations or land use regulations to prohibit and prevent landowners using their properties for what they purchased them for. And whether that's reef regulations, whether it's vegetation management, we're seeing now the EPBC Act at the federal level is going to be start to weaponise. So, anything you do, you're going to have to seek federal government referral. Even having debates about the voice and native title issues. So all of these levels of complexity make it very difficult for landowners to actually run their properties and to do the things that we want to do with them, is mainly grow food and sustain our communities. So, and we need organisations like Property Rights Australia to highlight those issues. If we all just walk away and say it's too hard and throw our hands in the air, well, we'll all be lost. We've got to continue the fight. And we're lucky that we've had people on boards of Property Rights Australia, smart, dedicated, passionate people who know what they're talking about, who can articulate those issues, as difficult as they are. And then we keep getting people signing up and supporting the organisation, because, there's lots of important battles are out there, and if landowners can't do it individually, they need to be part of a group. They need to be part of a larger organisation that has the resources to band together and fight these issues. And I'm particularly proud of my association, Property Rights Australia, on fighting those issues and working with the board and the organisation to continue to highlight those issues. Yes, we are. I actually think it's coal seam gas times 10. And we've seen in a very short space of time, certainly since May last year, change of the election, we've seen the government's actually legislated, the only country in the world to legislate 43% emissions reductions. And the only way we're going to get there is by electrifying or removing fossil fuels from our electricity grid. And you've just seen this huge tidal wave of investment, and mainly European investment, because the European countries own a lot of the renewable energy IP. Huge wave. But when I say huge, I'm not talking, millions. I'm talking billions of dollars. Multiple companies coming and wanting to do developments, and that's from wind to solar, obviously batteries, and then you've got power lines that connect all this stuff together. So no one within government, I have this conversation all the time, has actually sat down and worked out how we are actually going to physically do all of these activities. I had a meeting a couple of weeks ago with people from Powerlink, and I've got a lot of clients up around Billawheeler in that Callide Valley, which is one of the major electricity generation areas in Australia. It's got 3 major power stations, and there's 25 gigawatts of coal-fired power that's generated out of that area, and they've advised the answer to meet that capacity or that generation with renewables has to be 3 times. So 75 gigawatts has to be produced to use 25. And then you're going to need duplication of power lines. You're going to have upgraded substations. You're going to have implementation of batteries. And this is not all for free. This is billions and billions of dollars worth of money. This is just in one area. And landowners are stuck in the middle of this. They've got not a lot to say about some proponent wants to come up and put a 500 kVA power line up top of his house, or wants to put 300 wind turbines on his neighbour's place, or 10,000 hectares of solar. And the thing is, the scale of, like, when we first 2 or 3 years ago, you might be doing solar agreements for 1,000 hectares, and you think that's massive. They're now talking 100,000 hectare projects. Wind turbines, 30 wind turbines was a big project. Now you don't get out of bed for 300, and it's rolling at such a quick pace. And state government, they can barely tie their own shoelaces, and yet they are supposed to coordinate this mass rollout, the largest economic transition this country's ever seen, and they're going to roll it out in 7 years. It's just not going to happen, and the landowners are the ones going to be stuck in the middle of it. The only difference is with the renewables is landowners do have some power to say no. You don't have any power what your neighbour's doing. So we're having this happening a fair bit, where the first time a landowner knows a solar farm's popping up is when the trucks with the panels turn up. The power lines, yes, we've seen Powerlink do have powers of compulsory acquisition for their easements, but a lot of the power lines that companies are using are all private. So there is some power in that negotiation process, but the coordination process, coordination process of it is non-existent. You're seeing billions of dollars worth of investment flowing into Queensland. I had a meeting with a proponent the other day. They want to bring in 300 turbines. They've worked out that the Gladstone Port's not big enough, so they're going to have to bring them in through Townsville or Darwin. That's one project. There's 1 gigawatt project. So to get to 75, there's going to be 75 of those corporate proponents. So logistical nightmare. And it's not even for landowners. It's going to be for the local communities as well that are going to have to be foisted with all this. And we saw that in the gas industry. You had towns like Dalby and Chinchilla and Miles and Roma that were good, really sustainable rural towns, completely torn to bits when the construction activities were going ahead. And then when that all finished, it all fell in a heap. So and there's no government coordination in any of that. So it will be up to landowners to bind together and work together as communities. And we're actually starting to see that a lot. A lot of landowners I work for understand that what their neighbours doing has probably as big an impact to them as what's happening on their place. So actually getting to work together, communicating, and trying to work our way through some of these issues. But yeah, it's happening so quickly, and I really fear that there's going to be, like with the coal seam gas, the horse had already bolted before we even thought about it, the bridle. Same with the renewables, the horse had already bolted. These projects were already in train. The regulation will have to catch up later. As I said, it's paramount. If we don't band together, if we don't get together, we're just getting it walked over. And landowners, are fighting an ongoing battle against interests that are well funded, that are well organised, and have the direct drive to stop farming and the use of of land in Australia for commercial purposes. That's as simple as you can put it. And unless we work together in organisations like Property Rights Australia, and I'm also on that, involved with AgForce. I believe that we need our organisations to be strong and give us a strong voice. Otherwise, we're just going to get walked over. And we need support from landowners. I know it gets hard, and so why do we bother? But if we don't do it, the outcomes can be severe. And we've seen with Property Rights Australia recently with some of the advocacy work they did down around Waluga. You can see a bit of common sense come out of it. So my theory on it is you can't stop it, but you can certainly mitigate the adverse impacts where possible. And I'm very proud of the work that I did in the coal seam gas space, and the work that we did with different groups is while we couldn't stop it, we tried to at least minimise the impacts of the disturbance as much as you could on the landowners. And that was through good work as well with Property Rights Australia that did that stuff, that actually stood up and said, well, this isn't right, it needs to be fixed. So, and that's work that needs to be ongoing. And if we don't do it, well, we're going to end up in a lot worse place than we are today.
Tom, I appreciate your time and for your views looking back on your time with PRA. Thank you very much, mate.
Appreciate it, mate, and I hope the conference goes well. Sorry I couldn't be there for the weekend. Would have been looked forward to catch up with a lot of familiar faces and people I work with, but I'm sure I won't be a stranger in the years to come.